Many foreign investors and businesses operating in Vietnam believe that once a non-disclosure agreement is signed, their confidential information is safe. In reality, that assumption can be risky. An NDA in Vietnam is only as strong as its enforceability under local law. If the agreement is poorly drafted, too generic, or not aligned with Vietnamese legal principles, it may fail when a dispute arises. The key question is not whether you have an NDA, it is whether your NDA actually works in Vietnam. A common mistake we see is the use of global NDA templates without localization. Many companies copy agreements from other jurisdictions, assuming that legal protections are universal. However, Vietnam's legal system has its own requirements, especially when it comes to defining obligations, proving damages, and enforcing contractual rights. An NDA that works in the US, Singapore, or Europe may not be enforceable in Vietnam if it does not comply with local legal standards. This is where many businesses unknowingly expose themselves to risk. One of the most critical elements of an effective NDA in Vietnam is the definition of confidential information. If the definition is too vague, such as all business information, it may be difficult to enforce. Vietnamese authorities and courts often require a clear and specific scope. Confidential information should be categorized and, where possible, identifiable. This may include technical data, financial information, client lists, operational processes, or proprietary know-how. The clearer the definition, the stronger your legal position. Another key principle is reasonableness. Overly broad obligations may not be enforceable. For example, if an NDA attempts to restrict all information indefinitely without distinction, it may be challenged. Instead, the agreement should define the scope of use, the purpose of disclosure, and the duration of confidentiality obligations in a reasonable and commercially justifiable manner. In Vietnam, balance is important. The agreement must protect your business, but it must also align with legal expectations. An NDA is not just a statement of intent, it must include mechanisms for enforcement. This includes clear provisions on remedies in case of breach, such as compensation for damages, contractual penalties where appropriate, and obligations to return or destroy confidential information. Without these elements, even if a breach occurs, it may be difficult to quantify loss or enforce your rights effectively. In practice, enforcement depends heavily on how well these provisions are structured. Each NDA must be aligned with the specific legal context in Vietnam. For example, in employment relationships, confidentiality obligations must be consistent with labor law principles. In technology transfer or joint venture agreements, the NDA must align with the broader contractual framework and regulatory environment. A standalone NDA is rarely sufficient. It should be integrated into the overall legal structure of the transaction or relationship. Not all NDAs are the same. An NDA used in a technology transfer project requires a different structure compared to one used in an employment contract or a franchise agreement. The level of risk, the type of information, and the parties involved all influence how the agreement should be drafted. Using a single template across all situations is one of the most common reasons why NDAs fail in Vietnam. Even a well-drafted NDA requires practical enforceability. This means thinking ahead about how you would prove a breach. Do you have internal controls to track access to information? A confidentiality obligation supported by internal policies? Can you demonstrate that the information qualifies as a protected business secret? In Vietnam, enforcement is not only about the contract, it is also about the evidence you can provide. For foreign investors, the risk is not theoretical. Your competitive advantage in Vietnam often depends on your proprietary information, business model, and market strategy. If these are exposed without effective legal protection, the impact can be immediate and difficult to reverse. A weak NDA does not just fail legally, it creates a structural vulnerability in your investment. At LTS Law, we assist foreign investors and companies in Vietnam by drafting NDA agreements that are tailored to both legal requirements and business realities. We do not rely on generic templates. Instead, we analyze your specific situation, identify potential risks, and structure agreements that are aligned with Vietnamese law and practical enforcement. Our focus is not just on documentation, but on real protection. Before you rely on your NDA, consider this: if a partner misuses your information tomorrow, or an employee shares confidential data with a competitor, will your agreement hold up under Vietnamese law? If the answer is uncertain, it may be time to review your current structure. Visit lts.com.vn to consult with our legal team, and ensure your NDA in Vietnam is not just a document, but a tool that actually protects your business.